It's a pleasure to be back with all of you here on June 11th. And we have a full program to present to you as we toe that much closer to the actual days of summer. It'll be 90 degrees here in New York City, though, later this week. So I'm not sure it gets much more summery than that. But for now, Kathy, why don't we walk through the slides and I'll tell you what's happening for the next 45 minutes you'll be spending with us. All those times on the slide are Eastern. We know, of course, we have audience members who are here from other time zones. But I will begin with a brief summary of what's happening in New York State at the legislative level. The legislative session is done in all manner, essentially, unless there is an extension of the session, which we will get to in my comments in a moment. But a lot happened in the last week, some of which was relating to the session, but not, directly a part of it. That was congestion pricing and Governor Hochul's decision, which made national news, to call for a pause on its implementation. We will have Kamisha Parkins back on the program. Kamisha sits a few doors down from me here in New York City, and we will be discussing the implications of that, essentially breaking news. And then next we'll have Dory Bailey, who's with us from Syracuse, and she's been on the program at least once before and should be familiar to all of you. And she'll be addressing the implications of Cantero. And so that will be worth it for all of you with business interests that may well be guided by understanding that better. Stephanie Fedorka, staff, is back on the program. She sits in both Syracuse and Rochester, and will address complicated attendance and leave issues. David Bergio is also back with us from Buffalo, and David will address service and emotional support animals in the workplace. And then I'll wrap things up in about 45 minutes from now. But for the moment, let me turn to what has been happening at the legislative level in New York State. Last week, I was with you guest hosting, and at the time, when I was standing in for Kristen Smith, I indicated that there were bills that were moving through. We didn't know exactly what was going to happen. Social media involving kids in specific having stronger protections on access to and otherwise the data that are shown, more importantly, to kids. That was something that New York State was trying to legislate and tighten up to make social media a safer place for kids. That legislation has passed, so too warning signs at sites of gun sales. Data privacy protections, which was moving pretty quickly. We thought New York State might end up joining other states with legislation. That looks like it will not happen this year. And then the Grieving Families Act, which was uncertain at the time, that did get over the line. And to be clear, over the line means it passed both legislative houses, We still have to see whether the governor will sign bills into law as a general matter. That's the way it works here in New York. Next slide, please. Let's get into some of the details of what changed over the course of the week since I was with you. We did not know at the time that there was going to be this major announcement by the governor to pause congestion pricing. There are open questions, which Kamisha Parkins will address with you when she presents, on essentially whether the governor has the authority individually to issue the pause. Either way, certainly things have slowed down as a consequence of her announcement. The legislature worked vigorously into the morning of the 8th on Saturday. What I had mentioned to you last time we were together was that because the budget bill was several weeks late and included a lot of program activity within it, there was a general expectation there wouldn't be as much legislation passed overall in this last stretch of the standard session. It turns out that was right, except for this sidewinding, as it were, around the congestion pricing. In specific, if you look at this data that I found through Political Pro, there were 805 bills passed by the Assembly and Senate, as compared with 896 last year, which represents a significant diminution. There was at the very last minute, essentially a foray, a consideration by the legislature, whether they would find ways through tax or other means to essentially backfill for the cuts in revenue that are attendant to the pause in congestion pricing. The budget, of course, that was approved into law earlier this year that I was just mentioning, hangs its hat, as it were, on a significant amount of revenue from congestion pricing, in particular as affecting the Metropolitan Transit Authority. And there's not a very good answer for that at the moment in terms of how that gets fixed. So we'll hear more again from Kamisha in a moment about that. That picture, by the way, is one of an area that would be affected by congestion pricing. Full disclosure, it's outside my office, 39th and 3rd, looking down to 42nd and 3rd. Essentially everything in Manhattan south of 60th Street would be affected. And again, that is on pause for them. Next slide, please. So other bills that did make it through include a climate superfund bill. We also have downstate casino licensure expediting. We've had Jeff Gleason on before talking about essentially the gaming activities, including casinos, and there's effort to speed that along in the downstate. There's effort for more transparency in hospital closures. There's been a lot of press here in New York City about the closure of Beth Israel Hospital. That's part of the Mount Sinai system, and that was part of what spurred this legislation. Ambulance reimbursements, essentially allowing ambulances to get reimbursed for settings and rather for trips that may not result in a direct stop at a hospital. That's also gotten through. Red light cameras, if the legislature signed, or rather legislation signed into law, we'll have many more of them in New York City. Absentee drop ballot boxes. Essentially, what that means is across the country, as we have, as well as in New York State, more availability for absentee voting. The idea is to have other more flexible ways to collect those ballots. And so that's legislation in that spirit. Short-term rental registry is about looking at things like Airbnb and other short-term rentals and trying to build in more structure and transparency around where they exist in communities. And that is part of the push-pull that has been certainly across the country around these short-term rentals for the better part of a decade. New York's legislation is another step into that for it. So let's go to the no's. Medical aid in dying was closer than it's ever been in New York State, but did not get to pass both houses. There was language circulating around health access for undocumented immigrants, which also did not go forward. There was a call for a look back, essentially a nonpartisan panel to look at what specifically worked well and what didn't during the COVID-19 efforts of 2020 in particular, and thereafter as a state and otherwise we navigated the pandemic. The HEAT Act, which would have affected essentially bills and other forms of payment for fuel, that also did not make it through. Single-use plastic reduction did not make it through. There was a goal to essentially limit that. And then the Harvey Weinstein bill, in quotes. For those of you, of course, following the news, the Court of Appeals, the highest court in New York State, essentially indicated that the grounds on which a conviction of Mr. Weinstein took place in New York State were invalid because of certain forms of prior acts and evidence that were brought in a way that, again, New York State's highest court found invalid. There was a goal to fix that among certain legislators to ensure that would not be the case in New York in a future such instance. But there was a call, including by Speaker Hastie, to say we need to take a longer, fuller look at this because there are other implications that maybe the legislature hasn't had a chance to fully consider. And so that will be something I expect on the legislature's to-do list for 2025. So next slide, please, Kathy. Where we go from here is an open set of questions, really more than anything. We do know that the governor will have bills delivered to her through the course of the end of this year. The general rule of thumb is that anything sent to her, which in New York it's sort of a term that doesn't really mean what it says. Delivery means that the governor requests them, although they are technically delivered from the legislature. The governor then has 10 days, excluding Sundays, for bills sent from January 1st until December 21st, according to most experts, to approve such a bill. And if she doesn't act on the bill, it will be considered pocket approved, which essentially means that her inaction doesn't forestall the bill from actually becoming law. However, those sent from December 22nd through the 31st are on a different clock. That runs 30 days, and bills that aren't acted on in that period, even if delivered, are considered pocket vetoed, and which means that they won't be law. And anything that isn't delivered ultimately doesn't become law either. So we'll be tracking all of that very closely. And more on that as we move deeper into 2024. So with that, let me move to the next slide, which is my opportunity to introduce our next speaker. That's Kamisha Parkins, who is here to discuss the various aspects of congestion pricing. I really look forward to having an opportunity to learn more deeply as to what took place here in New York City and what the national implications were. And Kamisha is here to catch us up. Kamisha was on the program previously to tell us about congestion pricing because we thought it was important enough, given its role in the budget, to make sure that all of you had an awareness about it. But of course, then things really changed. So Kamisha, please, let's hear some more. Thank you so much for making this time.
Yes, thank you, Gabe, for that wonderful introduction. Hello, everyone. I'm back again to discuss congestion pricing. So, as some of you may recall, on March 27th, 2024, the MTA approved the congestion tolling program, which is now commonly known as the congestion pricing plan, for all vehicles entering the Central Business District, which is, as Gabe mentioned previously, the area south of 60th Street in Manhattan. So this congestion pricing plan was expected to begin this spring, but on June 5th, about a week ago, Governor Kathy Hochul did direct the MTA to indefinitely pause congestion pricing to avoid any added burdens to working and middle class families. This pause comes just over 3 weeks before it was supposed to start. Kathy, you can go to the next slide. So a quick overview of the plan is outlined in the slide featured here. Just to go over it really quickly, the daytime rates were supposed to be in effect from 5 a.m. until 9 p.m. each weekday, and 9 a.m. until 9 p.m. on weekends. Passenger vehicles, which are just typical drivers, were to be charged $15, with the toll being as much as $36 for larger trucks. And of course, there were toll rates during off hours, which are hours where there are not expected to be as many drivers on the road. The MTA did reserve the right to raise tolls on busier days where there's expected to be bumper to bumper traffic. The tolls were expected to increase to about 25% more. And there was also supposed to be an entry charge only, meaning that drivers will only be charged to enter the zone and not to leave it or stay in it. You can go to the next slide, Kathy. So there were also some exemptions implemented into the program. This included emergency vehicles, which were expected to be exempt. I've listed, the ambulances, the police vehicles, fire vehicles, and there were also government vehicles who were expected to be exempt, as well as buses providing commuter or transit services. Also, rideshares and taxis were expected to be exempt. They were just going to experience like a surcharge. For example, Uber and Lyft would have been subject to a $2.50 surcharge per ride. And there were also exemptions for low-income individuals in the city, including the residents who are making less than 60K a year, and then also drivers who earn less than 50K a year. And of course, there were people excluded from getting exemptions, This included public sector employees such as police, firefighters, transit workers, teachers, etc. Next slide, Kathy. So the outline purposes of the program was, of course, to ease congestion. And the plan was expected to reduce the number of vehicles entering the area by about 17%. And this would amount to about 153,000, I'm sorry, fewer cars in that large portion of Manhattan. The plan was also expected to generate revenue. I believe this is what was the huge benefit that has been discussed among media outlets, that MTA was expected to collect $1 billion in annual tolls, and those funds were expected to go toward infrastructure upgrades for the city's subway, buses, and commuter rails. Next slide, Kathy. So there were, and there are many concerns regarding this indefinite pause. And in a videotape message, Governor Kathy Hochul did state that a major factor in her decision was the concerns over the impact of the tolls on working people. I did include a quote here from her message that she delivered that says, "Circumstances have changed, and we must respond to the facts on the ground and not the rhetoric of 5 years ago." Many critics of the plan described the congestion pricing plan as unfair, uninformed, and unacceptable. And they all banded together to bring a lot of attention to the plan. And they believed that the public pressure that was brought it did work. They brought groups together from the left to the right, and they argue that it certainly did make a huge difference in driving Kathy Hochul's decision to implement the indefinite pause. On the other side, there are people who were supportive of the plan, which included political entities, drivers, and unions that felt that the pause, they celebrated the pause, and mass transit advocates and business leaders described the pause to implement the plan as a betrayal. They quoted, "We need transit funded properly, not protection for rich suburbanites." And this pause did leave a lot of unanswered questions, including how will the MTA make up the expected annual $1 billion in revenue? You can go to the next slide, Kathy. So going forward, Governor Kathy Hochul did want to make clear that there's a big difference between a pause and elimination. She does say that elimination was an option, but reinforces that she is committed to congestion pricing. There was a press conference on June 10th, just yesterday, that the MTA held, and the MTA chairman did mention that the MTA has to shrink their financial plans and their capital program. Specifically, the chairman, Janel Lieber, states, "We need the funding in order to move forward. We got a tall order and we're behind the 8 ball right now. And that's why we're taking these, frankly, serious steps to carve up the capital program and make sure we don't let the system fall into disrepair." The MTA does plan on moving forward without the funding coming from the congestion pricing plan, because the priority does still stand to be avoid reducing service, on subway lines, bus lines, and on commuter rails. And I do want to make clear that it is not over for congestion pricing, because it is still required by state law. However, approval from the New York Department of Transportation is not imminent. And there are also some implications on a nationwide scale, as New York was sort of leading the charge on this front. So Governor Kathy Hochul's decision does present some issues on a larger scale as well. There have been many other cities who have been looking into congestion pricing, and they will continue to do that no matter what happens in New York. However, if congestion pricing did go forward, it would have sort of quickened the process of implementing it in other cities. And so this indefinite pause simply just slows down that process of implementing it in other cities, as well as the lawsuits that are still pending. It specifically for New York State, it's very unclear what the outcomes of those suits will be and whether they still have any relevance with the uh, indefinite pause in place. That's where we are now.
Thank you very much, Kamisha. That was a very helpful set of comments that you worked through in order to catch us all up. I will tell you, I actually look out across the street at the governor's New York City office, which happens to be between 40th and 41st on 3rd. And it was pretty noisy out there for these last few days. There were lots of folks protesting the pause. And this is not, to my expectation, the end of this conversation. How long this pause lasts is, I think, anyone's guess. But certainly, Kamisha, you are welcome back here on the program as we learn more. And I thank you so much on behalf of the audience for taking the time to bring everyone up to speed. And with that, let me turn to our next speaker. We're going to be shifting gears a bit, and we're going to go to Syracuse. And Dory Bailey, who's a member in Syracuse and who has again been on our program before, will be talking about issues relating to your business and the Supreme Court with Cantero. It is a decision that has some wide-ranging implications. Dory has been published on this elsewhere, and I asked Dory if she wouldn't mind briefing this audience, and she graciously agreed. I am very appreciative. And so, Dory, thank you so much for coming on. I look forward to learning along with the audience assembled here today.
Thank you, Gabe. So as Gabe said, I'm Dory Bailey. I'm the chair of the Financial Institutions Regulatory Practice Group at Bond. And in this presentation, will discuss the recent decision of the U.S. Supreme Court in Cantero versus Bank of America concerning preemption of a state consumer financial law. Now, as background, in the United States, we have a dual banking system, and under the dual banking system, bank charters are granted by both federal and state authorities. So banks can choose whether they wish to be regulated as a state bank or as a national bank. Also, credit unions can choose whether they wish to be a federal credit union or a state chartered credit union. Now, one benefit of being a national bank or a federal credit union is the potential to have state laws preempted, meaning the state laws would not apply. Now, preemption is based on the Supremacy Clause of the U.S. Constitution, which states that federal law shall be the supreme law of the United States, notwithstanding any contrary state law. Now, in determining when national banks are subject to state laws, the Supreme Court has held that national banks are governed by state law with respect to, for example, contracts, purchase and sale of property, debt collections, and liability for debts that banks owe. So if the state statute, though, does not govern an area of law expressly reserved to the states, then preemption may apply. And one form of preemption is called conflict preemption. Now, conflict preemption, for example, applies when the federal law and the state law are in irreconcilable conflict. Now, an irreconcilable conflict occurs when compliance with both the federal law and the state law would be physically impossible. So, for example, if the state law said that banks within the state must open by 9 a.m. in the morning, and the federal law said that banks shall not open until 10 a.m., it would be physically impossible for a national bank to be open by 9 a.m. under the state law and not open until 10 a.m. under the federal law. So that would be an irreconcilable conflict, and the courts would be likely to find that the state law is preempted, meaning the state law does not apply and the national bank only needs to comply with the federal law. Now, conflict preemption also applies when the state law presents an obstacle to the accomplishment of the objectives and purposes of the federal law. And this type of conflict preemption is known as obstacle preemption. And obstacle preemption may occur when the state law is inconsistent with the federal law or when the effects of the state law hinder or interfere with federal policy. And this type of conflict preemption applies even when compliance with both the state law and the federal law is possible for national banks, but the state law infringes the national banking laws or imposes some type of undue burden on the performance of the national bank's functions. Now, the preeminent case in conflict preemption law for national banks is Barnett Bank of Marion County versus Nelson. And this case had to do with the National Bank Act, granting national banks the power to sell insurance in small towns. And the Supreme Court's analysis of this case focused on whether the state statute, which prohibited certain national banks from selling insurance, whether that state statute stood as an obstacle to the accomplishment of one of the purposes of the federal statute. And the court found in its analysis that grants of powers to national banks traditionally have been interpreted as grants of authority not normally limited by, but rather preempting contrary state law. And the court further found that when Congress has granted a power to national banks, that the state should not be permitted to forbid or significantly impair that granted power. However, states could issue laws that would apply to national banks, provided those state laws would not prevent or significantly interfere with a national bank's exercise of federally granted powers. And the court found that the federal law in this case explicitly granted a power to national banks with no indication that Congress intended to permit the states to restrict that power. And the court concluded that the state law could not limit a national bank's ability to sell insurance. So applying these legal standards, the court held that national banks could exercise the federally granted power to sell insurance regardless of a state law restricting the sale of insurance, and the state statute was preempted. Okay, now moving forward nearly 30 years, we have the Cantero versus Bank of America case that was recently decided on May 30th. Now, Cantero versus Bank of America concerns the New York General Obligations Law, Section 5-601, which requires banks to pay a 2% minimum interest rate on mortgage escrow accounts. Now, Alex Cantero and the other petitioners obtained home mortgage loans from Bank of America, and the loan agreements required the borrowers to make monthly deposits into escrow accounts. Bank of America did not pay the 2% interest rate on the mortgage escrow accounts based on the bank's view that the New York law was preempted by the National Bank Act. As a result, class action lawsuits were filed against Bank of America. Now, the Second Circuit in New York found in favor of Bank of America, holding that the New York law would exert control over a national bank's powers to create and fund escrow accounts, and therefore the state statute was preempted. But the case was then further appealed to the U.S. Supreme Court, and the Supreme Court found that the Dodd-Frank Wall Street Reform and Consumer Protection Act provides the legal standard for when a state consumer financial law will be preempted for national banks. And under the Dodd-Frank Act, a state consumer financial law is preempted only if the state law, number one, discriminates against a national bank as compared to state banks, or number two, prevents or significantly interferes with the exercise of the national bank's powers as determined in accordance with the legal standard for preemption in the Barnett Bank case. Now, the court found that the New York law in this case does not discriminate against national banks. So therefore, to determine whether the New York law is preempted, the law would need to be analyzed under the prevents or significantly interferes preemption standard under the Dodd-Frank Act. And the court also stated that because Dodd-Frank expressly incorporates the Barnett decision, the case would be decided in accordance with the Barnett case. Now, the court pointed out that Barnett did not establish a clear line to determine when a state law significantly interferes with a national bank's exercise of its powers. Instead, the court in the Barnett decision analyzed the prior case law where the state laws were preempted, as well as cases where the state laws were not preempted. So, for example, in an earlier case called Franklin National Bank of Franklin Square versus New York, the court held that a federal statute that permits national banks to accept savings deposits preempts a conflicting state statute that prohibits the word savings in advertising. And the court found that the New York law significantly interfered with the bank's power because the bank could not advertise effectively using the commonly understood term of savings to describe the federally granted power of receiving savings deposits. So the state law was preempted. Now, an example of a case in which the state law was not preempted was Anderson National Bank versus Luckett. In the Anderson case, the court found that a Kentucky law requiring banks to turn over abandoned deposits to the state was not preempted, and the court found that the state law demanding payment to the state after the depositors abandoned the account was no different than a depositor's ability to demand payment from their own account. So as a result, the state law did not infringe the national banking laws or impose an undue burden on the performance of the bank's functions. So the Supreme Court in the Cantero case found that a court applying the Barnett Bank standard needs to make a practical assessment of the nature and degree of the interference caused by the state law. And if the state law prevents or significantly interferes with the national bank's exercise of its powers, the state law is preempted. On the other hand, if the state law does not prevent or significantly interfere with the national bank's exercise of its powers, the state law is not preempted. And in evaluating the significance of the state law's interference, the lower courts would consider the Supreme Court's prior cases and consider whether the state law's interference is more like the Barnett and Franklin cases and therefore should be preempted, or if the state law is more like the Anderson case and therefore should not be preempted. And the court found that the Second Circuit did not conduct this kind of comparative analysis and did not analyze preemption in a way that was consistent with the Dodd-Frank Act and the Barnett case. So therefore, the Supreme Court vacated the judgment of the New York Court of Appeals and remanded the case to the Second Circuit to issue a new opinion using the legal standard described by the Supreme Court. Now, as far as the implications of Cantero versus Bank of America, I believe that if the lower courts follow the Barnett Bank standard, the overall effect of the Cantero decision on national bank preemption will likely be minimal. And although the Supreme Court did not provide a bright line rule, neither did the Barnett case or Congress when it incorporated the Barnett legal standard into the Dodd-Frank Act. So a court applying the Barnett standard just needs to really determine whether the state law prevents or significantly interferes with the exercise of the national bank's powers. And in determining the significance of the interference, the courts would look at Barnett and the prior cases discussed in Barnett. Now, that being said, the Cantero decision will likely increase the litigation risk for national banks. Based on the court's decision to not provide a bright line rule, national banks will likely be subject to additional challenges regarding the applicability of state consumer financial laws. So thank you very much for the opportunity to present on this topic, and please feel free to contact me with any questions you may have.
Dory, thank you so much. Really interesting information that you shared, and thank you for parsing it in such an accessible way. And we'll be looking forward to seeing whether your viewing forward as to the implications of this plays out in practice. And please come on the program to speak about this or any other meaningful court activity in the future. Again, thank you. And why don't we now turn to our next speaker for the afternoon, and that's Steph Fedorka, who is here. Again, Steph sits both in our Syracuse and Rochester offices. Steph is familiar to many of you as a regular on the program, and is here to discuss complicated attendance and leave issues. She's been presenting around the state recently on these issues, and I thought it would make sense for this audience also to hear a bit from Steph's perspective as to what's hot and topical here. So Steph, please go ahead. And again, thank you for coming on back.
Thanks, Gabe. Excited to be back on the webinar. Gabe challenged me to 5 minutes to talk about complicated attendance and leave issues, and leave laws are something near and dear to my heart. It's something I help a lot of clients navigate, especially because they've become quite complicated. Kathy, next slide, please. In large part because we have all of these different leaves that may or may not be into play. I'm not going to go through every single one of these leaves right now. We could spend a whole day on talking about the nuances of each of these leave laws, but this is to give all of you, visual representation. I'm a visual learner, so I like checklists and I like to-do lists. I like steps and kind of easily broken down memos and tips and tricks. But this is a visual representation of the various leave laws that we have or things to consider. And a lot of these, most of these, if not all of these, are protected. That means that when an employee is entitled to this leave, They cannot be retaliated against for taking the leave or using the leave in accordance with their rights under the law. Next slide, please. So my goal for the 5 minutes or, couple of minutes that we have today is to give you some practical tips for navigating attendance and leaves of absence, because they have become complicated. I think I'll say first and foremost, do not hesitate to reach out to a labor and employment attorney if you have any questions in where to get started, if you come across, what next step do I take? So here's some 6 steps that I like to follow in terms of navigating it. So step 1 is going to be having a strong and compliant written policy. Those are attendance policies, PTO policy, and leaves, right? Are they up to date? Do we have a written policy for that? Spoiler alert, you should have written policies for all of the big leaves, especially FMLA, PFL, paid sick time, if that applies. Even if you're a public sector employer and the paid sick leave law does not apply to you, you should have a written paid sick time and PTO policy so employees understand, right, what their terms and conditions are of using those leaves. Has the policy been circulated and distributed to employees? Where are they found? Who's responsible for administering these policies? And what is everyone's role and responsibilities in terms of, a supervisor? What roles and responsibilities do they have? Are they educated and trained on how they're supposed to manage attendance, leave, track attendance and leave, et cetera? And what are employees' responsibilities, right? In terms of reporting when they're not going to be at work, if they need to take a leave of absence or take time off from work. So always start with strong, written, up-to-date policies. Step 2 is going to be identify and understand the reason for the absence from work. Do you have all the information you need? So this is when the employee says, I need to be out of work tomorrow, or I can't come into work today. Do you understand, why that person can't come into work today? Of course, we caution that there are parameters and limitations on what you can and can't ask for, but you do as an employer have a general entitlement to basic information about why the employee needs to be out of work. You have some right to say, okay, is this a personal leave, PTO? Are they using it for something, or is it something that's protected, right? Is it paid sick time? Is it an FMLA qualifying reason? Is it because they have some sort of medical issue? Is it because their car didn't start, right? And each one of those things, the reason it's important to understand that is because your obligations as an employer in terms of how you administer the leave, if you can hold someone accountable for calling in, last minute or not, is going to depend on why they needed to be absent from work. Someone calling in to work because their dog is sick, right, and they have to take them to the vet, right? As hard and difficult as that is, and I'm sure many of us with pets have been there, that's not a protected leave of absence. So you can hold them accountable under your attendance policies and call-in policies. But compare if someone has paid sick time, they work for a private employer, and they call in sick because they have to take their child to the doctor because their child is sick. If they have that time accrued, they are protected. So even if they call in at the last minute prior to the start of their shift, they are protected for that absence. So it's always important to understand and track, right, why that person is absent from work. Another reason that's important is because I see this come up in, say, annual reviews, right? Someone will say this person had a lot of attendance issues. They get docked a couple points, but this person took FMLA leave, PFL leave. So you can't take those protected absences into account in terms of raises or performance evaluations. You can't count those negatively against that person. So it's important to understand, again, why is this person not at work? Step 3 is going to be identifying what policies and leave laws apply, right? Identify what internal policy applies and what leave law, if there's a leave law, right, that may apply in protection. And what interaction and interplay there may be. There may be several leaves that are running concurrently at the same time. Someone who is using PFL and FMLA for the same qualifying reason, say to take care of a family member with a serious health condition, those should be running concurrently. So understand and kind of make yourself a list of what potential leave laws and policies apply. And then step 4 is going to be communicating with that employee regarding the leave, whether that's approval, expectations, and other issues. So things that need to be communicated include notices, documentation, and certification that might be required. For example, with the FMLA, you have to provide that notice of rights and eligibility, and you should request the certification if you can ask for certification if that's the one of the reasons for FMLA, say a serious health condition of the employee or their family member, and give that to them within 5 days of knowing that they need to be absent or need to take a leave of absence for an FMLA qualifying reason. Include a due date. If you're asking for information to support the leave, if you're entitled to that, you should always put a due date on when the expected return of that information should be provided. Don't just leave it out there indefinitely. A lot of times clients will call me that they sent, the employee their information that they needed from the healthcare provider. We need a doctor's note, or we need this, or we need that. And it's been out there for 2 weeks and the employee has been out but has not provided the information. So I always recommend and strongly encourage including and communicating a due date, right? And that due date might depend on what exactly the purpose of the leave is and what laws allow or require in terms of that time frame. The dates of the leave, always try to include a return to work date. You should understand, you're generally entitled to understand when that employee can come back to work. Generally you don't have to grant an indefinite leave of absence, right? With no return to work date in sight. So try to get that information at the outset so that way you can say, okay, this person is on a leave of absence for 6 weeks. And then you can set a reminder, which is kind of going into step 5 of when you're going to check in with them. Any expectations while they're out on leave in terms of not working, if they have to leave anything, leading up to the leave, any sort of plans, anything that needs to ensure continuity of operations. Information about continuation of benefits is also important, particularly expectations with respect to payment, their employee share of any contributions while they're on a leave of absence, if it's paid or unpaid, use of PTO time, those types of things. And then return to work expectations, including if you're going to require a medical note for them to return to work, an expectation of communicating with the employer or HR, right, about any changes in terms of if there's any changes, if they need more leave, if they can come back sooner, whatever it may be, that they have to communicate that. And any repayment of advance on contributions, for example, all of that should be laid out ideally before the employee goes out on leave. Step 5 is going to be set reminders to follow up. Don't harass or communicate with the employee. I generally say don't communicate with employees when they're on a protected leave of absence, unless there's some justification. So unnecessary communication, unnecessary updates. You really should be leaving those folks alone, but it's okay to check in. And I actually encourage employers to check in maybe a week or so before the conclusion of their leave. We're eager to have you back. Please let us know if you need anything. As a reminder, this is what we expect from you when you return in terms of if there's a return to work note or something like that. Let us know if you need any accommodations, whatever it may be, kind of a welcome back so that, it's clearly communicated when they're expected to return to work. And then step 6 is to be prepared to navigate changes. So I have a little roller coaster icon there because I think a lot of times these leave laws take on a life of their own and they can twist and turn, and you have to be prepared to work through changes, updates, including accommodations. When they come back to work, some employees, if they took the leave for their own personal health condition, they might return to work with certain restrictions, right? So you're going to have to be prepared to handle extensions for leaves of absence, as well as accommodations or any other issues. And then importantly, very, very importantly, if an employee has taken a protected leave of absence, right, we want to be very careful and mindful of avoiding retaliation claims. So that's not to say that they get a get out of jail free card in terms of all wrongdoing because they went on PFL and are returning to work. But we need to be really mindful, right, again, in terms of not counting those absences with respect to any increases in pay or promotions or counting them negatively or anything like that, as well as being mindful again of any sort of adverse employment action that comes right on the heels of them taking leave, requesting leave, or coming back to work. That could be viewed as retaliatory. And that's what I have for you. Don't hesitate to reach out. These can get complicated fast, and we're here to help.
Thank you so much, Steph. You stuck basically to 5 minutes. You totally stayed within those parameters. Thank you. Pause and policies will be on the agenda next week. What David has to say is very interesting, and we want to make sure that you have the time to listen and really absorb it all. So sit tight for that. And next week, Kristen will be back as your host. And then I will be with you in 2 weeks' time. If you have questions about any of the presented material, of course, reach out to us. You have our email addresses in front of you, and we are always delighted to answer your offline questions. And we thank you as well for your continuing loyalty to the program. We look forward to having you all back in a week's time. And in the interim, please enjoy these last days of spring and stay safe out there. Be well.